is working its way through the Michigan legislature that seeks to even out parenting time in the event of a divorce. And here to talk about the proposal and its potential impact is Elisa Peskin-Shepard of Transitions Legal. First of all, tell people exactly what you do.
I am a family law attorney and mediator, and I focus solely on family law, work with families all of the time.
And what is the current law right now for shared custody?
Well, the custody law right now requires that the court take into consideration the best interests of the children. There are 12 factors that the court may consider when determining what is in the best interest of the children and determining what an appropriate parenting time schedule is going to be. So the legislation that's proposed right now, House Bill 4691, as you mentioned, takes away the best interests of the children, takes away the focus on what's most important for the children, and tries to impose a cookie-cutter solution for every situation, in making it mandatory for the court to order substantially equal parenting time. The proposal does not allow the court to award any party more than 200 overnights of parenting time, regardless of the particular circumstances of that family and of those children.
So you are against this bill?
I am against this bill.
And the main reason is you feel like it's not one size fits all.
Correct. You can't have a one size fits all when you're talking about children and their situations. You can have a situation where a parent hasn't been involved at all with the children. We have this all of the time in our courts, where somebody files for trying to get child support, trying to determine who the father it might be of the child, and that father hasn't been involved with the children at all. And all of a sudden, because an action is filed for a custody or parenting time, if this new bill is passed, then the court has to start from a point presuming that there should be a substantially equal parenting time. But that parent may never have been around the children at all. And we have a large number of cases where that could happen to those children and affect those families through generations. I
know some people have argued that, hey, look, it seems like it's traditionally weighted in the favor of mothers in many states around the country, and that oftentimes fathers don't get that time with their children, and once it's gone, and they can't get it back. And they say that the current law pits parent against parent instead of thinking about the child first.
That's absolutely not correct. In fact, the current law, it states the primary focus is the best interest of the children. And even if you look at under our current law, which was passed in 1970, so it's been around for, 47 years or so, by focusing on the best interests of the children, and with the times as they've changed and both parents are involved in raising their children when they file for divorce.
If you start there with the best interests of the child, you should be covering all the bases. We're out of time, unfortunately, because we could talk more with you for sure. If people have more questions, where do they go?
They can call me at my law firm, Transitions Legal.
You got it. Awesome.
Thank you,
Thank you, Lisa. We appreciate it. We'll be right back.